Okay, so this round is now being recorded.
Okay. All right. Is anyone not ready? Okay. My name is Claire Sawyer. I use she, her pronouns, and format is essentially going to be talking about it's basically just going to be going over some like definitions, weighing mechanism in the case. Time is 7 minutes, so it starts now. My partner and I firmly affirm the resolution. This House prefers the American rule to the English rule. Now, in some background, the English rule requires that a loser in a civil lawsuit pays the winner's legal fees, and in the United States, the winner usually pays their own legal fees. Obviously, there are some exceptions, what I'll get into later. But essentially, like our observation is that we're like sticking with the status quo, right? We prefer the American rule to the English rule, and our weighing mechanism for today's debate is going to be net benefits, which is the most amount of good for the most amount of people. Moving on to our first contention, which is working class people. So essentially, what the American rule was established to do is to ensure no one would be hesitant to file a legitimate court case due to the fear of having the legal fees on both sides. So essentially, the American rule uniquely benefits people without access to like these big fancy, because they're more likely to lose cases as a general principle, right? So basically, to put this into a more like contextualize this more. So Feldman in 2022 finds that the English rule is a bad thing for working people because essentially when you have these big insurance companies, instead of because they can spend all this money on these fancy lawyers and things like that, ultimately it means that like if a normal person that's trying to sue like an insurance company for say wrongful death of a family member or something, being left permanently disabled, things like that, then they will ultimately like they'll end up paying a lot more money because they'll not only be paying for like they won't only be paying for like the lawsuit, but they'll also be paying for like the other person's legal fees if they lose, right? So and this added risk of provision, what it does is it actually prevents people from going to trial, because in the end it's going to work against accident victims and provide insurance companies with one more way to harass those making claims against them, right? So ultimately, like our links, first is we have increased corporate control. So when citizens lose the massive resources of corporations, they're put into way more debt than they originally agreed to. I mean, it's already hard to fight against like massive corporations, right? As an individual with maybe one or two lawyers. I mean, the difference in income between just a normal person and like a massive insurance corporation, like maybe Blue Shield Health or something like that, is like huge, right? So if you're forcing people, if they lose a settlement, to pay the other's legal fees, even if they were the ones suing, then like it discourages people from going to trial for like actual legitimate reasons, right? And not only does it do that, essentially it will increase the amount of settlements, right? Because instead of going to trial and having the risk of paying another person's legal fees, essentially what will happen is the lawyer's going to come up to this person and be like, hey, I advise you to settle because you don't have enough money to pay for all these other people's fancy lawyers. So I mean, just like take the settlement. I know, this like bad thing happened to you, but just take less money than you actually deserve. It's kind of the same concept as, like plea deals with criminal justice. Like almost 95% of like cases in criminal justice end up with a plea deal. It's essentially like people encourage uniquely low income people and people who, or even middle class people who just can't afford massive legal resources, to just take the settlement, and like it doesn't promote justice, right? So moving on to the art impact. So essentially what this leads to is that civil rights cases or any cases against major corporations will essentially just get swept under the rug rather than being discussed. And so without these cases, there will be less questioning of institutions and the status quo, and it reduces the quality of life in regards to safety cases and civil rights cases, and people end up wrongfully like completely destitute and have even more, and corporations have even more power to exploit their citizens out of their money. And so second contention is that the American rule encourages justice. That point A is it discourages retaliation. So let's get a scenario first. So if you're sure that you're going to win a lawsuit and are mad at the other person, you can essentially just spend hundreds of thousands of dollars on legal fees so that you can make the other side pay even more. Or even if they're suing you and you're mad about it, but you have like more money and more ability to get better lawyers, then of course you're going to spend a bunch of money, so then they're going to like have to pay, right? It essentially prioritizes winning money over justice being served. Also, another important note, if you drain somebody's bank account, then they're probably not going to fight back against you again. The the American rule discourages this this from happening. Sub point B is that it allows resources to be utilized to further just causes. So, for example, the first successful asbestos suits followed unsuccessful and costly failures that gradually unearthed the facts. Had the plaintiffs and their lawyers been further burdened by the responsibility for the defendant's lawyer bills, then success would have definitely been beyond reach. We see that the same occurrence like happened with big tobacco. So essentially what happened is that they gradually unearthed lies instead of having all their resources drained from having to pay for the company's team of fancy lawyers, right? I mean, it essentially like levels the playing field in a way, because it's not like, oh, I can spend as much as I want on lawyers without any consequence. Like you have to you have to exercise restraint, right? So ultimately, like, yeah.
Why?
Yeah, I'll take the question.
Sorry, would you mind re-explaining the example with big tobacco? Sorry, I just don't think I completely understood what your point was.
Okay, so it's the same concept with like asbestos. So like had the plaintiffs and their lawyers been further burdened by the responsibility for the defendant's bills, then success might have been beyond reach. Essentially, like if like the companies that were using asbestos or these big tobacco companies could have like completely drained the other people's bank accounts by making them by making them pay all their legal fees, then they'd be less likely to fight back and like have another lawsuit against something else that they did, right? It essentially discourages it. Does that make sense? I'm gonna go with yes. All right. So moving on to our impact for this contention, it essentially allows for further research down the line on previous cases. So, like without this case, we wouldn't have been able to research the impact of unsafe hazmat suits or firefighters. We wouldn't have been able, we literally would not have been able to like research the unsafe impacts of cigarettes and actually like regulate big tobacco, and like sue them for the lying to the entire American public, right? Similarly, the American rule is more favorable to plaintiffs than the English rule in cases where the defendant's recoverable expenses are greater than those of the plaintiff. So, having to pay the defendant's expenses would be disproportionately burdensome. So, like, yeah, essentially, like, the entire point that we're trying to make is that you shouldn't have to pay. Like cases that go to trial are generally legitimate cases. They're not just they're not just going to sue people for random things because it costs a lot of money and time, right? So like basically it doesn't make people pay more. Like it doesn't have as much of a risk if people lose, and it usually benefits the working class, and for these reasons you're affirming.
All right, off-time introduction. I'm April Mao, and I'm going to be the LOC from Campolindo and off-time roadmap. I'm just going to be going over the negations case and then the affirmations case all in order. If everyone is ready, my time begins now. Jumping right into it, the first contention is going to be about reducing abusive lawsuits. So the overview here is that we see that in American law, even when a defendant wins a lawsuit, he still ends up losing because of the fact that he has to still pay for that price. But number one here is that currently there's a lot of lawsuits in the United States that are over things with little importance. We see that subpoint A here is an example. There's a $54 million lawsuit against small Washington area dry cleaner that saying that they had lost a pair of pants that was remarkable not only for the astronomical damages claimed, but also the $100,000 in legal fees that incurred in successfully defending against it. We see that this is a very common thing with a lot of like small businesses. For example, in this case, it was a dry cleaner, but a lot of small businesses where they get sued a lot, and even if they do win, they still lose a lot of money, which is really detrimental to their business. So point B here is that we see that people just in general oversue in America. We see that American rule often assumes that it intends to encourage like plaintiffs to sue because even if they fail, they will not have to pay the defendant's legal expenses. We see that subpoint C here is that according to the Duke Law Journal, encouraging litigation that is likely to what happens with the English rule is that it's able to encourage litigation that is likely to succeed and tend to discourage a lot of the litigation that is likely to fail. This is because the incentive to select a lot of this like meritorious cases is already in place because the contingency fee system places much of the burden of losing and also going unpaid on the contingency fee lawyer, and who therefore selects whether like these cases are a matter of like self-preservation or not. So number two here is that we see that losers pays if the loser pays discourages a lot of abusive lawsuits. So point A here is that the rationale for the English rule is that a litigant is entitled to legal representation, if successful, should not be left out of pocket because of their own legal fees, right? Specifically, so point B here is that losers' pays would be an important part of a larger effort to reduce a lot of litigation costs and better compensate like prevailing like litigants and better align a lot of like law with its like goals of like deterring socially harmful conduct. So basically, by reducing the expected costs to defendants of like fighting these abusive suits, this proposal should probably weaken the ability of the plaintiffs and their lawyers who would file them to induce the defendants to settle. So subpoint C here is an example, like when Florida instituted a medical malpractice loser pays thing, which was basically the English rule, but specifically in medical things, there was actually a really large increase in dropped claims, and the lower rate of trials suggested in Florida's loser pay laws was a promising experiment that the lawmakers abandoned too quickly. Like we see that loser pays almost halved the shares of these medical malpractice lawsuits that went to trial from 11% to 6%. So the impacts here is that we see that there's less likely to be abusive abusive things. There's less costs those being sued, like specifically like seriously hurting someone's economic chances, even though they did nothing wrong. Specifically, we see a lot of this with small businesses. Yeah.
So you say that the number of cases went from like 11% to 6%, but how do you know that all of those are frivolous? What if people are just afraid to go to trial because of the consequences?
I think we're not sure about the details, but definitely a lot of this was because, well, the whole point, why things were dropped because lawyers realized that it's no longer needed to go to court for these cases. If they were really serious, which is the 6%, if those really serious cases still ended up happening, it's just those like smaller, more frivolous cases that ended up getting filtered out. But onto the second contention, which is just like the cost of litigation. We see that like just in general, the U.S. law system is really costly. We see that subpoint A is that the direct cost of like litigation reached $247 billion in 2006, or 825 per person in the United States. And a lot of these tort costs in the U.S. as a percentage of GDP are far higher than the rest of the developed world, which is double the cost of Germany and more than 3 times the cost of France and the United Kingdom, who all use the English rule. So we see that just in general, the American rule makes it really difficult for and impossible to assert claims when the cost of litigation exceeds this probable recovery. So yeah. Moving on to the affirmations case, we see that on the first contention, a couple of responses here. Number one is that they tell you about how they make sure that no one is hesitant. But we're going to tell you, no, people will be more hesitant because they can't afford things even if they win. Specifically, this is key. We see that the English rule basically checks back against this because it examines the case, and if it sees that if you have evidence, they award insurance in the case that you lose. So if you actually have the basis to sue without good lawyers, you won't basically be scared to legitimately sue. So this actually, the English rule is actually a better check back against this stuff for the working class. But also they tell you about how like citizens are going to be put more in debt. We're going to tell you no, like people turn like small businesses are going to be sued as well. Did you see that up to 53% of small businesses are involved in at least one lawsuit at any given time, and the threat of litigation impacts small businesses across virtually every single industry, because they have to pay even when they win, and that's been really, really detrimental to small businesses, which was even worse under in America under the American rule, right? We see that also they tell about how people are always going to be suing large corporations. We see that the only place where people are always suing large corporations is in America, which uses the American rule. So you're going to actually turn this point against them because it's actually under the affirmations world in which this actually happens. I tell you about how if you drain someone's bank, they're probably not going to fight back. That's like the American rule. But judges, there's a reason that America is the only country that uses this rule, and there's a reason why the American legal system is not always going to be the best. You're going to turn this point on them also because you make justice worse, because it's often not your fault when you get sued. There's a reason, especially for small businesses, there's a reason why the U.S. has the largest number of abusive cases without merit. They tell you about this whole big playing field with big tobacco. We're going to tell you that it's probably like suing corporations and everything is like not going to be like really unique to like America. This isn't going to solve the big tobacco thing. We see that, like, see how workers sued the government over a lack of like COVID regulations. Not only that, but see how in the UK tobacco companies have regulations over like packaging, access to minors, and safety because of lawsuits in the past. The only places that have this is in the UK, which utilizes the English rule. So if the English rule is bad, how are they still able to sue the big companies, right? We've seen that in those countries, the English rule has worked and has been able to change things, which is direct warrant for for how it works. All of these issues, all these issues about the status quo being bad that the affirmation brings up to you is just another reason to vote neg, because that proves to you that the status quo in America is bad because we use the American rule. Now, just like other couple things to like just keep in mind is that like a lot of the times like the small businesses getting sued is going to be more impactful than like large businesses getting sued, because like when large businesses are getting sued, they can like fight back against this, but small businesses cannot. So basically, in conclusion, so corporations are going to be sued in either world, in the app world or neg world, they're both sued. But it's the frivolous lawsuits against the small businesses that are going to be unique to the US and unique to negation ground, which is why you will be voting for negation today against the American rule. Thank you.
Really
So really quickly, I'm gonna set up a timer for 8 minutes. So really quick off-time roadmap. First, I'll begin by going over the negatives case, and then I'll go over the affirmations case, and if time permits, I'll start weighing out today's debate. So with that being said, I'll begin my time in 3, 2, 1. Judge, I affirm. So let's go down the flow with the negatives case. So firstly, their first contention is talking about reducing abusive lawsuits. However, and they basically state like this is specifically against small businesses. So basically they basically talk about the impact of frivolous lawsuits, but they don't talk about how the court system actually deals with frivolous lawsuits, because frivolous lawsuits aren't really common. Yes, when the media, like whatever cases actually do end up going through, the media does cover them, but a lot of frivolous lawsuits end up being dropped because our legal system is already overloaded. So that means judges and like whoever's in charge already throw out these cases in the first place because they're not applicable. So like, yes, we hear a lot in the media about like small businesses getting sued over minor things. However, a lot of the court cases that don't end up in the media end up getting thrown up already. Also, the American rule has several exceptions in certain situations in order to mitigate this effect. So some of this can be like the parties have a contract to have an agreement that will like reduce this, or there's like a statute that allows the imposition of fees. There's a wrongful conduct of the defendant forces a plaintiff into litigation with a third party, or like whatever. There's a bunch of exceptions right here that prevent these frivolous lawsuits from going forward, especially when like the plaintiff is forced to defend against malicious prosecution. So all of these cases end up like mitigating a lot of the effects of frivolous lawsuits. So the question is, why do we have these frivolous lawsuits in the first place? Well, it's clearly not because of the American rule related to the English rule. I think it's more attributed to the fact of like the American system and the American way of fighting for rights and whatnot. People in America are more likely to fight back against like what they consider to be a crime against themselves, and therefore, because of that culture that we have in America, we have a lot more frivolous lawsuits. It's not because of the American rule. So that's clearly here. So like in terms of like reducing abusive lawsuits, the American rule like already has exceptions built into it to prevent like frivolous lawsuits. But secondly, our legal system is already very overloaded, so judges will throw these out. So because of those two like refutations, like their entire point kind of doesn't stand. But also, give me 1 second. So, but like now into like their Florida malpractice case, so they basically stated like something went down from 11% to 6%. However, they didn't actually specify the reason why people were dropping these cases. A lot of the times, especially when you're talking about medical malpractice, a lot of these people might like they will be like scared to actually go to court and will be incentivized to settle, which like we talked about in our case. Yes.
So you yourself say that the American system is already overloaded, which is probably bad because it leads to court clog, right? So wouldn't you argue that a law that discourages overloading the American system and discourages more cases would actually be good in the current clogged system?
So in terms of, yes, I agree, like there is a clogged system in America, but I don't think the American rule or changing it into an English rule like will actually defend will actually fix that problem. In fact, I think it would be even more important to have like that system in place. Like I strongly believe, and I think like the point of the affirmation is that like we're basically stating you need to have the ability to file a court case. That's like really important because you're fighting against sometimes like large corporations or small businesses. Some organization, some group has done some sort of harm, and the ability for someone else to protest against that using a court case is fundamentally democratic, but also fundamentally useful for that person. And that encourages a lot of like beneficial things and whatnot. So yes, there might be some frivolous lawsuits, but that overburdening isn't even attributed to the American rule. But also, even if you were to say it is, I believe it's more useful to have it than not. So now into like carrying on with our case. So overall, they talked about like this Florida malpractice law. However, like they don't address the fact that people will be scared to go to trial just because of that huge fine that they may have to face just because of like they don't have the resources of even a small business which might be making lots of money. So overall, like pretty much the Ned case doesn't stand because they failed to consider the exceptions to the American rule that like really reduce the amount of like abusive lawsuits that they may have. So like now let's go on to the Gov case and like go over the things that they said towards our case. So firstly, our first contention is about like working class people and how just because they're working class and they don't have those resources just of a corporation, they're already hindered from winning. In fact, like working class people are less likely to win because they don't have access to those resources. So they basically state like that like a lot of these cases are even thrown out because they don't have the evidence, and like they should be only going to court if they have the evidence. But the problem is a lot of evidence is found during the trial. The trial incentivizes courts or lawyers to go and dive into the facts and see what the issue is, and that's what the entire point of the asbestos case and the tobacco case. They found these issues related to tobacco, they found these issues related to these hazmat suits because of this trial, and that's absolutely key because a lot of evidence is found during these trials. And if you don't go to court, you lose pretty much any evidence that you have there. And that's really important because you shouldn't force people to end up settling and not actually dive into these issues. So so that like main point, please flow that across, Judge, because that's super key to this case. So like even so like once again, you could cross apply a lot of our refutations that we had against their case to like their refutations to ours, because like they basically state like the only like impact is like small businesses. So like just overall, like the idea is to have an even playing field, because even if people spend needlessly, they're making sure that someone else will pay for their grievances. Will pay for we'll pay, like we're just making sure that there's an even playing field between working class people and those who might be the head of a small business or the head of a corporation. So now onto our second contention, which is like encouraging justice. So they basically use this entire court clog argument to say that like justice becomes worse because it's not often your fault when you get sued. However, a lot of these lawsuits against small businesses are literally big businesses suing them over IP laws. The negation does end up becoming worse for small businesses, but also like they talked about like why England has better like tobacco regulations when like the United States does. However, like in Europe, they're better at regulating corporations, which is why you see less frivolous lawsuits or like quote unquote frivolous lawsuits, because they already have the regulations there, when the United States is a lot more free market overall. So like they basically, so like comparing the American system to the English system is really hard to do because of the regulations and rules that they have there against like business overall. So it becomes really difficult when you're trying to compare these two systems, and like and saying that one unnecessarily spends and another one doesn't is really hard to compare against. So it's uniquely necessary in the United States to regulate businesses through lawsuits because the government isn't doing it. And that part is really key here, Judge, because in terms of like encouraging justice, you have to make sure that like people in the United States have the ability to regulate the business because the government doesn't have the ability to do so because of like various other like systematic issues. So like let's start weighing out today's debate. So firstly, a lot of the government case goes pretty much unrefuted so far. So like please flow through like the amount of exceptions that the American rule has, but also like the fact that like the government doesn't have the ability to regulate things, so the people have to, but also how the negation becomes a lot worse for small businesses overall. So overall, you're voting for an even playing field on the affirmation, while the negation encourages a larger disparity. Thank you.
All right, let me get my timer. Okay, hello everyone. My name is Ava Spalding. I'm going to be the MO for the negation side of this debate. Just for a really quick off-time roadmap, I'm going to start with the negations points in the order they were read, and then moving into the affirmations points in the order that they were read. Oh gosh, I need to clean my computer so it doesn't die on me. Sorry, I didn't had low battery. Okay. If anyone's not ready, I have 8 minutes, and my time will begin now. Starting on the first contention. So let's look at some line by line of the affirmatives responses. So the first response that they give you is that basically this doesn't talk about how the court system is specifically dealing with this frivolous lawsuits. However, my partner has given you a pretty clear outline as to how this actually happens. So in the world where we adapt the English rule, what happens is that you are basically there are a couple things that happen. So first, there's the self check back in terms of, do I want to do this? If I do my cost benefit analysis, if there's a chance that I don't win, which is probably high if I don't have evidence, I'm not likely to go in, waste my own money in court. Like we tell you how American costs are like 2 times higher just for the amount that's spent on court cases in general. Money that could be better paid investing into other sectors, but money that could be better paid as just like consumer confidence, like putting into other businesses, right? Is wasted on the legal system. So that's one part. And second, we do see that that people are eligible for insurance specifically if they do end up having to pay the other person's legal fees. And this is if they have enough evidence. Now, I'm going to get into this point more later, but that's just something key to keep in mind. And then, so next, I want to tell you that frivolous lawsuits aren't common. Now, this is really, really untrue when you take into consideration America. We see that America has some of the highest rates of frivolous lawsuits, as well as the highest number of examples of frivolous lawsuits specifically against small businesses. They try to wave off, okay, well, you're just aware of this because there's so much media coverage of it. But exactly, there's so much media coverage of these instances because they are absolutely insane and really aren't happening anywhere else. You may have noticed that my opponents haven't given you any instances of frivolous lawsuits in any other places. And so really the only examples of frivolous lawsuits we're seeing are in America. For like, if you look at that Washington area dry cleaner example, that's still flowing through here. Next, one really key thing that I want to point out that my opponent tells you in the MG is that they admit that court clog that the American system is already overloaded. And I ask in a POI, well, if the system is overloaded, doesn't that mean that we should be focusing on reducing the number of these frivolous cases? And my opponent tells you that I don't think the English rule would fix it. Now, this is going to be one of the main reasons why the affirmative loses this round, because they kind of failed to give a good response to this POI. And so I want to outline that people still have the ability to sue if they have good reason and evidence. But if they're going to lose anyway, it doesn't matter if they're going to lose this lawsuit versus if they're not going to run it at all. The only unique impact that comes from this is the exuberant legal costs. This is reflected in the 2 times amount of legal costs that we see in America. And we see that if we do implement the English rule, this would 100% fix the frivolous lawsuit issue in America. Now, judges, it's just common sense. If you do a cost-benefit analysis, say you want to sue someone, but you probably know, for example, like if you're doing this because you like, even if you don't have enough evidence, you probably know that you're not going to win. Now, if you're going to have to face legal costs on this frivolous lawsuit, there's probably not a reason for you to do this. So therefore, the English rule would fix this. Even if you don't buy my reasoning, this is still reflected in the Florida example that we bring up. We tell you that these like legal cases reduced by half, reduced from like 11 to 6%, almost half the amount. So this is actually reflected in reducing court clog. So even if you don't buy everything else we tell you about small businesses, about how this is better for justice, there is that unique impact of court clog that we 100% get access to. Now, my opponents bring up in the Florida example that there's no way that we can prove that these are frivolous. However, if you would drop a case just because you might have to pay something for it, this probably means it's frivolous and it wasn't that important anyway. So now let's talk about just extend the entirety of the second contention through. That doesn't really get any reputations, and that's kind of all done on other sheets in terms of like reputations about the cost. So I'm not going to get into that. So now let's go. No, thank you. Now let's go on to the first contention of the affirmatives case about the working class. So a quick overview on this contention is that sure, the working class is definitely important. They should be able to sue. However, my opponents fail to tell you or to prove why the working class is the one mainly being sued in America. Now, my partner gives you this really good analysis specifically about how it's small businesses, not working class people, or these large corporations that are getting sued more often in America. We see that up to 53% of small businesses are involved at least one lawsuit at any given time. And so small businesses are really the targets of all of this harm. And this goes conceded in the MG. And so this is going to be a really, really key point here, because often small businesses are the ones who are not able to handle these exuberant legal costs. Even if they win the lawsuit, even if they did nothing wrong, they are then put into a bunch of debt specifically because they have to pay for the good lawyers that are going to get them out of that we're going to get them out of the leadership anyway, the lawsuit anyway. Now this has really, really big impacts because small businesses are very, very key to our economy. We see that they're responsible for 90% of new jobs. They're very responsible for innovation as well as capital generation. And so small businesses are undoubtedly a key facet of our economy. And if we're just allowing them to pay the cost of getting sued, even when they've done nothing wrong, that is really not only bad for our justice system, but it's bad for our economy in general, which impacts every single American who might be on poverty, on the brink of economic recession, right? We have a lot of huge impacts coming from that. So continuing on this contention, my opponents try to bring up this example about how if they try to refute our example about evidence found in the trial, how evidence is more often found in trial than before it. However, no one goes to trial without evidence. No one goes to trial without a claim. There has to be some basis for this. And even with that considered, if there is evidence that people know would be uncovered through the trial, then this means that they're still going to go to court, and then they're going to win, and then there are like no unfortunate causes of that. So if there is evidence, and if people know that there's going to be evidence because they're not suing frivolously, there are no negative impacts. So that still flows through. No, thank you. I don't have time. Continuing, my opponents talk to you about tobacco and hazmat suits. If all of this is true, how did we get tobacco lawsuits in England? We literally bring up to you examples about how the reason that we have tobacco regulations in England is because there have been lawsuits before. They try to give you this reputation about how in Europe they're just better at regulating corporations. That is because the regulations came from suing. You sue and then a regulation gets made to prevent that from happening again. The regulations just didn't get put in place and like automatically. That's just not how it works. And so we see that all of these suing instances are happening in Europe. They also concede the fact that we see that like workers sue the government over a lack of COVID regulations. If everything the affirmation is telling you is true about how no one can sue in England, and people are just scared to, the working class, the people are scared to sue, why are we seeing so many of these large lawsuits against corporations in England? That doesn't really make any sense. Onto the second contention. So my opponents try to tell you that in the status quo, it's big businesses suing small ones. Exactly. Big businesses right now are abusing their power and suing small businesses. It's very, very clear that small businesses are the ones that cannot afford this. So with all that said and my line by line work done, I want to do just a quick summary of the debate. Overall, you're going to be voting for the negation here because of small businesses. Small businesses are the backbone of the economy and inherently have a ripple effect over everyone because of the jobs they provide, the wages they give, the new capital they generate. Now, currently in the status quo, American small businesses are being targeted by bigger businesses, by corporations that are currently suing them. Even if small businesses do everything right, follow the rules, and still get sued. If they win their case, they still lose. Ultimately, small businesses are hurt by the American rule, which then in turn hurts all of the American people. The only way the affirmative is going to get out of this debate is they're going to try their best to go on the justice point, but we've still proven that A, people are going to get litigation insurance if they really have evidence, and B, if people really believe in their cause, then they're still going to go to court and be able to win. For those reasons, I would strongly urge a negative ballot. Thank you.
All right. So once again, it's April, and the off time roadmap is just all on a separate sheet of paper. It's going to be 4 minutes on the weighing. So yeah, separate sheet of paper is best. Okay, if everyone is ready, my time begins now. Jumping right into it, ultimately, you're going to be deciding this debate based on what is most probable. Specifically, a couple of reasons why probability comes first is that number one, probability controls the internal link to magnitude. We cannot even access the magnitude of impacts if there's no chance it's going to happen. But also, number two is that it's best for policymaking, it's best for making decisions. There's always going to be a risk to everything in life. So we should always make our decisions based on what has the most amount of risk so that we can actually do stuff about that, right? There's always a chance of something happening. Number three is that magnitude invisibilizes the structural violence that is currently ongoing and everything. So a couple of reasons why the negation here is winning on probability is that since people are 100% likely to have to pay more if they lose, which is it's probably going to be more probable that people will double think about everything they are going to do before they actually go and sue. Now, this is probably going to decrease a lot of those frivolous cases. We give you the warrant about Florida that flows completely through. That's a very direct warrant for what happens when we actually instate this law, is that those who did not need to sue ended up deciding not to sue. Number two, what is also really probable is that the court clog in the status quo will be solved, right? The affirmation themselves concede the fact and tell you themselves that there is so much court clog in the status quo. The reason why is because all these people are going to the courts. Now, we see it in Europe, there is no court clog, which probably proves to you that the English rule is definitely going to decrease court clog. But the third thing here is that if you look to all of our things, all of our warrants and analysis about why your UK, Germany, everything about how their costs are lower, they're still taking tobacco companies into the courts, it's everything. It proves to you that it's so much better over there, and the US is the only place that uses the American rule. Like I said in the LOC, all of the warrants that the affirmation tells you about how the status quo is bad is just another reason to vote net. Now, a couple of reasons why we will be winning on specifically the small businesses first, because the small businesses is also a really big probability, because number one, we see that 53% of the small businesses are already in something like this. Also, number two, large corporations can take the lawsuits. They're the ones that are abusing the power, like the affirmation said, that are abusing their power against them. We see that if small businesses are sued, they lose no matter what, and the small businesses are the working class people that the affirmation tries to argue for, which means that they ultimately hurt the own people that they're trying to argue for. You're just going to extend everything my partner tells you about how small businesses is really key to the economy, which probably means that it's really probable that with this we also always do really badly economy wise. For some preempts. Number one, do not let the affirmation come up here and talk to you about tobacco, because specifically you look to all of the things we tell you that goes cold conceded about the lawsuits in England. There's a reason why those companies in England are so well regulated, like the affirmation says, because they are able to get taken to court and actually lose instead of abusing their power. And number two, do not let the affirmation come up here and talk to you about justice, because what is justice is people going to court with evidence, right? What is justice is big companies not being able to abuse their powers. What is also, even if you don't buy that, justice is very low probability. Here's a couple of reasons why affirmation still doesn't win on justice. We see first, small businesses already being unfairly sued and have to pay the costs even if they win, which is already a violation of justice, which happens in America, which is the only place that utilizes the American rule. Second, people who care about their cases and have evidence are going to get insurance, or that evidence will be uncovered in trial, like the affirmation themselves say, and win their cases. Then no harm will be done. Basically, in conclusion, vote for the team with the most real-world analysis about how the real English rule has worked in other countries and how it will work in America. Therefore, you vote negation for the protection of American small businesses. Thank you.
Speech format is just basically going to be, wow, my phone will unlock. Okay, speech format is basically just going to be going over voters in impact way. So yeah, float on a separate sheet if you so choose. All right, so with that, 5 minutes, my time begins Now, Judge, we can see that today's debate has come down to a few main points, and we explain to you why AF wins on all of them. First is this point about working class people. They tell you that small businesses are victim to lawsuits. That's exactly our point. They argue against themselves in this, because essentially we're telling you that small businesses are mostly sued by large businesses, right? And if small businesses are going to lose to large businesses every time, then they're also going to have to pay all of the large businesses' lawyer fees, right? It literally makes no sense. If a small business lose, which they disproportionately do, they will like be destitute every time. If anything, you turn this like you obviously turn this point onto our side, because it's way worse for small businesses and working class people who are working at those small businesses. So again, our original point still stands, right? Working class people are the ones suing or being sued, right? So even if they sue, if they lose, they'll be like legitimately destitute, right? If they're suing like a big insurance company, but they lose and they end up having to pay their fees. Again, we tell you that the issue is not frivolous lawsuits, and under the English rule, it means that people are uniquely in the US court system and in other corrupt court systems, people are not incentivized to actually go to trial and get what they deserve simply because they're not incentivized to go to trial and get what they deserved simply because they have this risk of paying hundreds of thousands of dollars, right? That's our entire point, and we're winning on this. Second, moving further into this point about frivolous lawsuits, they tell you that lawsuits are frivolous. Like, frivolous lawsuits only happen in the United States. They like never happen anywhere else, which first of all, I think is a pretty absurd claim to make. But yes, sure, there are going to be lawsuits that are going to be frivolous in pretty much any court system. It's unavoidable to have a couple. But Judge, I'd like you to take this logical analysis over everything else. If you're a judge and you're looking at a case and you know that your court system is pretty overloaded, are you going to take a case about a $52 million pair of pants? Unless you're some random judge with bad judgment in Florida, probably not, right? You're going to take cases that actually matter. And the only cases that actually matter are the ones that end up going to court, right? So uniquely, though the crowded judicial system isn't the best, I mean, it uniquely filters out frivolous cases. And just the judgment of judges as a neutral party filters out frivolous cases in and of themselves, right? So not only are we winning on this point about working class people, we're also winning on this point about frivolous lawsuits. Don't let their argument about how lawsuits are if you drop a case it wasn't that important anyways flow through, because that's really not true. Even if you're wrong, we tell you that you could be scared to lose your entire livelihood and not be able to feed your family, even if an insurance company didn't properly cover you, right? So third is this point about settlements, and we tell you how people are forced to settle to get less than they deserved. And this happens very often under the English rule, and this was completely not responded to by the affirmation. So even if you don't give us access to the first 2 points, we went on this point. Fourth is this voter about English regulations. So basically they just hone in on this one example about big tobacco and tell you how big tobacco has all of these regulations, right? And how it's good, and so that happened because of suing. First of all, they missed the point of our argument, but to get into this specific regulation, we tell you that the United States legal system is fundamentally different from Europe, and so is their governmental system. We see that ours is much more inefficient, and people actually need to take individual action in order for these regulations to be put in place, rather than people politicians actually acting for the good of the people. They act for the the pockets of tobacco companies, unlike those in England, because there are laws against corporate donors and things like that. So ultimately we're winning on that point. But moving on to the actual point of our argument, they basically just our point is the fact that when they don't really properly respond to the fact that when you're suing somebody and you drain their entire bank account by making them pay all your legal fees, they're less likely to sue you again, right? And this is uniquely with the economic inequality in countries like the US, is uniquely a problem, right? All right, so moving on to some impact weighing. So essentially we're winning on magnitude because essentially the magnitude of the impacts is what we see in other countries, or what we would see if we implemented the English rule everywhere. Is because of the nature of the United States court system, we find that the magnitude of the impacts is massive. People are just not going to get what they deserve. I mean, we already see this with plea deals in the status quo. People accept plea deals 95% of the time. Same thing will happen with civil court cases. We also win on probability because it's very probable that all of this is going to happen, because we give you a very clear logical warranting, right? In this case we tell you in Texas, the risk of provision prevents people from going to trial, and so instead of paying the $2,500 difference between the original settlement offers, the defense could end up paying $29,819 plus interest to Android and $16,407. So instead of paying $2,500, they're paying $50,000. All right. Essentially what I'm trying to get at here is that under the affirmations world, you make sure that people aren't afraid to go to trial and to get money for things that actually deserve, and you prevent like massive corporate control and the ability for big corporations to literally sue like small businesses and working class people within an inch of their life. Thus, you're voting app. Thank you.
Good round, y'all.
Good round.
Good job, guys.
Okay, so we'll take a few minutes to fill out the ballots and make our decisions, but you can stay on the call because we'll be back with some feedback. Okay, so I believe that both judges have submitted their ballots. So everybody here? Violet, you want to go first?
Sure. So the decision was split. I voted for the government team and Arden voted for the op. And I can just give a brief explanation of my decision, and feel free to ask me any questions or email me if you think of something later. So I think this was an interesting round. Everyone pretty much agreed on the weighing mechanism of net benefits, and there were pretty clear arguments made on both sides. Thinking about in particular, well, I guess I'll just kind of go like on the line by line, right? So I think a big point that kind of came up later in the debate is like this point about frivolous lawsuits and like the number of lawsuits that are going through the system in court clog. And this is kind of where the opposition gets a lot of their ground from. I think there were several responses, or at least a few key responses, that kind of get ignored from the negative side. In particular, the government team makes this argument that a lot of frivolous lawsuits actually end up getting dropped by either party or thrown out by some kind of judge, and that there's a number of exceptions to the American rule due to like contract or other statute. I think just reiterating the fact that basically we hear a lot from the negative team about how there are going to be so many frivolous lawsuits filed, but I don't think there's much of a response to the affirmative argument that like many of these lawsuits either get dropped or thrown out early on in the process, which I think does a lot to mitigate the impact of like the money that might be wasted or like the time that might be wasted going through the whole like lawsuit process. I also think a lot of the responses on the other arguments are quite general when it comes to talking about the American system versus the European system. So thinking about the example that was discussed about big tobacco, we hear that, oh, in the UK, like all this legislation came about, like even though they have the English rule, like how did that happen? And I think AF also kind of specifically responds to this by saying, you know, not all of these broad societal changes can be attributed to this rule. About how lawsuits are settled. It could be due to a cultural difference or just a difference in how frequently people tend to bring about lawsuits. Maybe like Americans do it more often. So I was broadly convinced by those 2 points. It was the mitigation on the frivolous lawsuits and also sort of the offense on just the fact that people are going to be scared to bring about lawsuits that they legitimately believe in. One response we do get from Campo on this is that like if you drop your lawsuit because you were scared to go to court, like it was probably frivolous to begin with. But I just don't think that's super responsive to the argument that people just fear losing a large amount of money.
Okay, should I jump in?
Yep, go for it.
Cool. So I think for me, the biggest mistake that is being made in the round, and it is being made, I think, by both sides, but especially by Granite Bay, is the lack of terminalization of impacts. I hear things like, we solve for court clog. Oh no, we solve for court clog. And I don't know why I care about court clog. Or I hear things like, we have in the past led to tobacco regulations. And I'm thinking, okay, So what other sort of regulations do you think that are going to come out of this and that will be beneficial in the future? And what is the actual impact? And how does that weigh against anything else in the round? So I get a lot of arguments thrown out there that are neither terminalized nor weighed against each other. The only argument that I heard that I thought, okay, this is actually pretty terminalized, or at least there's an attempt made at terminalizing it, is small businesses, which is the weighing that comes out of the second speaker on the op, which says small businesses are key to the economy because they produce 90% of new jobs and just they're the engine of economic growth, and they get people out of poverty and so on and so forth, which is not amazing weighing, and I don't even know if it's true, but it's the only weighing and the only terminalization of any argument in the round. So then I start thinking about who wins the small business impact. And this is where it was actually very difficult for me to decide. I was kind of going back and forth. But I think the basic argument that I hear from Campolindo is that the biggest, like there's lots of different lawsuits with different people on different sides, but apparently the most common one is the instance of a large corporation suing a small business, shaking them down for some sort of IP violations. And so in that scenario, which rule would be better for small businesses? And the next says, well, in the world of the English rule, sorry, I misspoke. In the world of the American rule, small businesses pretty much lose either way. Either they just lose outright and then they're screwed, or they somehow manage to defend themselves, but then they still lose because they have to pay all these lawyers. And that's bad. And then maybe small businesses go out of business and people lose their jobs. And there's a response that I'm hearing from the AF, which is actually pretty good, which says that small businesses are more likely to lose than they are to win, because small businesses don't have very good lawyers. And then if they do lose, now on top of paying their own court costs, they also have to pay their opponent's court costs. And that's even worse. So if you're a small business, you'd rather lose some money than like lose double the money, which is a very good response. And I think that turns the impact. The problem, and maybe that argument was made earlier, but I wasn't able to find it in my flow. I'm getting that argument very clearly articulated out of the rebuttal, but I'm not really getting it clearly articulated out of the constructive. Whereas for the op, I'm getting from the very first speaker to the second speaker, and then to the rebuttal, they're carrying over that same argument. And so I feel like if I voted on the turn for the AF, it felt to me a bit newish, at least in that context. So that's why I ended up voting for the op. The last thing I'll say, and this deals with the way in which both sides are weighing in the rebuttals, is that when you're trying to weigh in magnitude and probability, I think you're just fundamentally misunderstanding what it means to weigh in magnitude and probability. Magnitude and probability are ways to compare specific impacts. So you can't win the round on probability. You can't just say vote for us because everything we say is most probable. You win the round on a specific impact, like for example, small business is an impact, and you weigh that impact against other impacts using probability or magnitude or time frame or whatnot. But you can't win the round just on the general concept of probability. And that goes for both teams. And the AF tried to do the same thing in their rebuttal, where they said, we control magnitude and we control probability. To me, that's like saying, we win because all of our arguments are more logical or something. Like that's just not how you weigh. So yeah, if y'all have any questions for me or Violet, now would be a good time to ask them.
So, sorry, this is just in regards to like terminalizing your impacts. So, like in a value topic, how far do you have to go, if that makes sense?
The same extent that you would in any other round.
Okay, so
Like you said that the standard is net benefits, right?
right.
So the side that wins is the side that accesses net benefits more. And if you prove that your version of the legal rule, whether American or English, benefits the most people, then you win. And small businesses creating 90% of jobs seems like it accesses net benefits better than court clog that I don't know what court clog does.
Right.
I don't think this is a question of policy versus value.
Okay, yeah. I was just wondering because I mean, I've had some judges say that when you're terminalizing your impacts, you like always have to relate it to like deaths or like war or like climate change, which I feel like is not.
I think you need to relate it to net benefits for a lot of humans.
Okay.
And war is a way of doing it because war affects a lot of people.
Right. Yeah.
But I think like poverty also affects a lot of people. And so if a bunch of people lose their jobs because their employer got knocked out of business by a lawsuit, that seems like a terminal impact.
Yeah. Okay. Yeah. Thank you.
Yeah. Cool. You good? Or any other questions? All right. Good work, everyone.
Thank you so much. Great debate.
Thank you. Bye, everyone.